Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to take your U.S. immigration related questions. So if you have a question, go ahead and put it in the comments so that I may answer your questions. So let me formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their permanent residence and status in the United States. I am also here every night at 9 p.m. to answer your U.S. immigration related questions. So go ahead, get comfy, and put those questions in the comments. Let's talk about your immigration issue and let's see if I can answer your questions. So I usually come with a topic to talk about, and tonight, while your questions come in, of course, because your questions are my priority. So feel free to put those questions in the comments, anything that's immigration related, and it doesn't have to be related to the topic that I'm talking about tonight. But I also come with valuable information, and tonight I'm going to be talking about applying for permanent residence through Vawa. What is it? I want to explain exactly what it is, because many individuals think that they don't qualify for it when they indeed do, and it can help to solve other issues, especially if you're here, you're without your papers, and you want to stay in the US. It also, you can get a work permit while you wait for the approval on the Vawa, and you can use the Vawa to then go on and get adjustment of status. So who qualifies for Vawa? So anyone who's if you're being mistreated, abused, subjected to extreme cruelty by a U.S. citizen or resident spouse, if you're under 25, a U.S. citizen or resident parent, or a U.S. citizen, son or daughter who's 21 and up, then this is for you. Now, one major question that I get, or concern that I hear is, will applying get my relative in trouble? And the answer is no, because the officer is using the information that you have provided to make a decision as to whether you should get status in the United States. It's not for the purpose of sharing it with outside agencies to start an investigation of your relative. It's not for that purpose. So that's one concern that I want you to be reassured about. Now, once you know that you qualify for this, and let's talk about mistreatment, by the way, because that's an important part of qualifying for this. Now, in order to qualify, you have to be mistreated, abused, subjected to extreme cruelty by a U.S. relative, the U.S. relatives that I previously mentioned. Now, what does this look like? What does mistreatment look like? So the first is, are you being verbally abused? Are you being mentally, financially, emotionally? This does count. Physical abuse does count as well, definitely does. That's a clear-cut reason that you would qualify for this. However, there is a misconception that you can't qualify if there was no physical harm, if you weren't injured, and that is not true. If you are in a situation where you are being mistreated, then the rule of thumb is you should get legal advice and confirm whether you qualify. Now, once you determine that you qualify, the next step is to apply for this. So what does the application process look like? So the first is that you submit the relevant forms along with the evidence. Now, evidence of mistreatment can be anything that is believable, any believable evidence. So that means anything that's credible. So your statement, a psychological assessment, pictures, text messages, transcripts of conversations, taped conversations, etc. You can even be creative with the evidence. Social media postings, where if your spouse, your parent, or your son or daughter they're posting things on social media and embarrassing you, this does count. And so it can be any evidence that sheds a light, that shows in some way that you are being mistreated, abused, or subjected to extreme cruelty. With some individuals, you'll apply for the adjustment of status application, and that will allow you to get the work permit within 6 to 8 months after you've submitted everything. In other cases, it depends on your relative. You would have to wait until your VAWA application is approved, which is taking around a year to get the approval. Once you get the approval, though, you would also automatically receive your work permit. And that work permit, of course, would be able to give you some comfort, some relief while you wait to apply for permanent residence, because at the time that your VAWA is approved, you'll also apply for adjustment of status, which means apply for permanent residence in the United States. So let's talk about some of the benefits. But before I go on, I want to remind you that I am here to answer your immigration questions. So feel free to put those questions in the comments, because that is my main priority. I also come with information, but you are free to go ahead and put your questions in the comments about your immigration issues or questions, anything that's immigration related. And keep in mind that if you have that question, hundreds of other individuals have those same questions. And so you help to guide the conversation. You can help me to give you information that you care about and that others care about. I brought my wife, but she hasn't yet received her 10-year green card. We just filed. Can I file for my parent? So yes, Sanchez, you can definitely do that. You just want to make sure that when it comes time to apply submit the affidavit of support, that you can show that even with your wife, you can financially support your parents as well. And in order to see if you meet the income requirements, you could go to uscis.gov and you can look up the I-864P form. And that is going to list the household size. So it's based on the household size. The household size, the state that you're in, and how much income you should be making based on the household size. Hi there. Good night, Princess Dial. It's nice to see you. Cramram, I have a U.S. green card and been out of the U.S. for over 12 months because of closure of country border. Will I lose my green card status? So it is very much possible. What I know, COVID is one of those extraordinary circumstances. What you will definitely need to do is apply for a special type of immigrant visa. It's a returning resident immigrant visa at the embassy, and that would be able to allow you to return to the U.S. And then, of course, follow up to make sure you reestablish your permanent residence. So that is going to be important. But now keep in mind, though, that the information I'm giving you is general, Cramram. You need to schedule a consultation to get specific legal advice, because it's just general information. I don't know what your situation is. I do need details to be able to give personal legal advice. So I don't do that on the live. I give general information to help to guide you a bit. What you can do is call 561-405-4889 and schedule that consultation. You can also go to the link in my bio. It will take you to the website where you can see all the ways you can get in touch with the firm. Can someone work on a tourist visa? Thanks so much, Amiga, for your question, because I get this often. And the answer is no. You cannot work on a tourist visa. It's not permitted. You would have to apply for a type of visa that would allow you to work in the U.S. Is there a question of paternity? The child is not in the father's last name, but wants to attend. If there's a question of paternity, the child is not. So if the child wants to attend the funeral and they're applying for a visa, then, it depends. So is the father on the birth certificate? Now, I think you're talking about getting a visa. That's what it sounds like. And so the first is, do they qualify for the visa? That's not the first one. And then secondly, if they do have any questions about, the paternity, which would be kind of extreme for our visitor's visa application. But if they did, maybe you could provide evidence of paternity. However, paternity is usually something that comes up in permanent residence, but not visitor's visa. So 3, God bless. If you really would like legal advice, you can schedule a consult. Ram, you are welcome. So U.S. Embassy open for visa. It depends on what country you're in. Some countries they are not right now. They're not handing out visitors visa. So it depends on which country. What you can do is you can go to the embassy's website in your country. So for example, U.S. Embassy in Kingston, Jamaica, and look to see if they're giving any updates on what they're doing. My husband has his interview, but now my mother died. We want to go to Jamaica for the funeral. How can we? So my husband has his interview, but now my mother died. We want to go for the funeral. So it really depends on the timing of the interview. If you do want to go to the funeral, and your husband has his travel document, that could allow him to go. However, if the date of the interview clashes with the so if those dates clash, they're in conflict, you have to really evaluate whether you want to put off that interview and call them and reschedule under the circumstances. So you definitely, if you really would like to help with figuring out what to do, you can schedule a personal consultation, because the information here I'm giving you is general. It's not personal legal advice. But in a case like this, if they conflict, you would likely have to decide what you want to do. Do I get notified when immigration receive my application, and how long is that wait? So Samantha, the first, it depends on what you're applying for, but it could be a few weeks later. You should get a receipt notice that would tell you they received it and they have accepted it and they're processing it. Can the family abroad help get here? So they can definitely, provide a letter stating the reason that the child is wants to travel to the United States. However, it's not totally dependent on the family. What the officer wants to know is that the child is going to return to the home country after they have attended or visited the U.S. temporarily. I need to go pick up my 10-year visa. A long time it's up there. And okay. So Jason, good luck with that. Can I renew my 2 years green card without a spouse after it expires? Yes. So there are ways. However, the ways depend, user 544, on what your circumstances are. Were you mistreated, subjected to extreme cruelty, or abuse? That is one way. Have you been divorced? Because if you are filing for divorce or you have been divorced, you can submit a waiver based on the divorce, or you can submit a waiver based on extreme hardship. With the divorce and the mistreatment, you have to show that the marriage was real, but that the marriage just didn't work out, or that you were being abused and you had to get out of the situation, or you're being mistreated and that's why your spouse is not applying for you. What you should do is schedule a consultation. This is what I help my clients with. And so you can definitely get more detailed personal legal advice in a consultation. You can call 561-405-4889 and go ahead and schedule. I was adopted 25 years ago. Guyana Department wanted my aunt to live here for 6 months before. So princess style before. So she said forget it, and that was it. What can be done? Well, adoption is more complex. So if you were adopted 25 years ago, so it sounds like you were adopted as a child. And if you're adopted as a child, you'd have to meet certain requirements, and it really depends on the type of country. So the process depends on the country. And so it's important that you schedule a consultation, because that is definitely complex territory, but there may be a way. So I urge you to get legal advice in a consultation. How long will it take for a company to file a green card for you? So it depends. Right now, some of them are current, but it depends on what type of employment visa you're applying for. Is it a EB1, EB2, or a national interest waiver? Is it an EB3? So it depends on what type and which country you're from, because the processing time is going to depend on the country. So keep your questions coming, because I am here to answer your immigration questions. I am U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their green card and status in the United States, even if you're out of status. Earlier, I was talking about the Vawa process, but I'm also answering your questions, which are great, and these are the exact questions that I want to get. Just did my biometrics last week. How long should I wait for my EAD? So I can't tell you how long after the biometrics, because right now biometrics appointments are all over the place, but you could be looking at 6 to 8 months after you have filed your application. So go ahead and keep putting your questions in the comments. I'm finishing up the topic about applying for Vawa. It is one way that individuals often overlook when it comes to fixing status in the United States. And Vawa is for individuals who are being mistreated, subjected to extreme cruelty by a U.S. citizen or legal permanent resident spouse. If you're under 25, a U.S. citizen or resident parent, or a son or daughter who's 21 and up. So I filed my application August 2020. So then it's a year. And so there have been certain cases where they're going over the time. So what you can do is you can check the processing time, at the service center that's processing your case, and see what is their range of time. And if you're over that time, then you would have to look into doing a case inquiry, and that can sometimes give it a little nudge, because 12 months is definitely far over the average time of 6 to 8 months. So keep your questions, but there is a backlog going on, and so you do have these situations, but make sure you pay attention to your case, look at the case processing times to see if you're over the time, and then see if you can inquire as to why it's over that time. So keep these good questions coming. Your questions can really guide a good immigration conversation. It can help me to give you information that you care about. So keep putting those questions in the comments. So what is an I-484? So I know the I-485, and the I-485 is the application to adjust status in the United States. And that means to apply for your permanent residence while you stay in the U.S. Now, it is only for certain individuals who can maintain their legal status in the United States, so the application didn't expire, or individuals who are immediate relatives of U.S. citizens who came with a visa but it expired. Immediate relatives of U.S. citizens are spouses of spouse of a U.S. citizen, parent of a U.S. citizen who's 21 and up, or a son or daughter who is under 21 and unmarried. Also, it is for individuals who are, for example, going through employment based and can maintain their status, of course, and humanitarian. So if you're going if you're adjusting status as you've received asylum, a T or U visa, and now you want permanent residence. How long a Caribbean spouse of green card holder take to come to the USA? So right, it depends. It depends. So you said green card holder. Right now you're looking at 18 to 24 months. But Latoya Plus, it's a good time to apply as a spouse of a green card holder because it's current. There is no wait list for an immigrant visa number. And what that means is as soon as your petition is approved, it goes straight through and is prepared for the interview and scheduled. Now, keep in mind that doesn't mean that it's going to be a 6-month process. It still means that it's going to be 18 to 24 months, which, believe it or not, is a faster process than the others. However, it is taking about a year for the I-130 to be approved and then another 6 months to get that appointment scheduled. And of course, that depends on the amount of time you take to get your documents in. Hi, can one apply for a green card if they've already applied for the B1, B2 visa? It may be possible. In some cases, I've seen individuals apply. Latoya, you're welcome. I've seen individuals apply and get it, and then I've seen other individuals apply and get denied. It really depends on your particular circumstances and whether the officer believes that based on what they have in front of them, you will return, even though you have a pending I-130 that you will return. But keep in mind that if, for example, if you have a very long application, so say your application, your I-130 process is going to be a 14-year process. I've seen visas approved in cases like that. How long does it take for an F2B category to be approved? So that is taking 5 to 6 years. And F2B is the unmarried son or daughter of a green card holder who's 21 and up. Keep those questions coming. Do you know anything about prevailing wage determinations? So that is where you have to file the labor certification. And that is the most complex part, and that is where it can take the longest. So first, you do the labor certification, and that is where they do the prevailing wage determination. And then if that is all goes well with that, then your employer can file the petition, and then the petition with the labor certification attached. And then from there, it goes through the process and then the processing time. So that part of it is additional time that you have to factor in. And it could be 6 months. However, if there is an audit, it can take more than that. It can take 80, it could be turned into a year to 18 months. Nice 923, you're welcome. So keep those questions coming. Now, I want to let you know that Norbel Strike, thanks for sharing the live. Now, I want to let you know that I am going to go over to Instagram right now at 9:30 actually. So I'm still here, still put those questions in. But the conversation doesn't have to end here. You can hop on over to Instagram with me and continue to ask your questions, especially if I don't get to your question by the time you put it in here. Now, if you can't make it over to Instagram, you can go to the link in my bio and click on the Instagram button and it will take you to my page and you can wait for me over there. So right now, do you think there is an audit when it comes to prevailing wage determination? So yes, so possibly. Now keep in mind that the audit is it's not every single case, but your case could be, or one person's case could be. Latoya, Jolene, what you can do, it really depends on what type of green card that you're applying for through your employer. So what you can do is schedule a consultation and then we can talk about your employer and the particular options that you have in your situation. Shanice, thank you for sharing the live. I appreciate that. What is the bill the president is trying to pass to give permanent residence to undocumented people? So right now, Jolene, you are welcome, and I really hope to hear from you to help with your options or help to advise. So with the bill right now, he is trying to propose that individuals can gain permanent residence or conditional residence if they show that they can register and pay taxes. So it hasn't passed, it's not law yet, but we're keeping a close eye on it, and hopefully something happens soon. So I am going to head over to Instagram right now. You can go to the link in my bio, click the Instagram button, and it will take you over to the Instagram page, or I'll see you tomorrow at 9 p.m. again, where we can have this conversation and you can ask your questions. If you would like to schedule a consultation, go ahead and call the number on the website. So go to the link in my bio, go to the website. The scheduling coordinator is available up until 11 p.m. tonight, and Monday to Friday, 9:30 a.m. to 11 p.m. and Saturdays, Sundays, noon to 5 p.m. So if you would really like legal a consultation, go ahead and schedule with the scheduling coordinator. I'll see you on Instagram in a minute, but if I can't see you on Instagram, then definitely I'll see you tomorrow night. Have a good night, everyone. Bye.